We're here today with Tim Reeves of the Oregon 10th Amendment Center, and we're going to talk about the Constitution. Now, Tim, I know when I was growing up, I went in history class, and then I had one of my instructors was talking about the Constitution, and specifically he mentioned something about the necessary and proper clause. He made some suggestion that actually meant that our Constitution was a living Constitution. It meant that there was, some built-in flexibility or something to it, and he felt that was an important part of allowing the Constitution to change with current events and the modernization of our lifestyle and such. What are your thoughts on that?
Well, that's a common misconception. My teacher had the same idea. He gave me the same concept. He specifically said something like, well, there were no cars in 1789 when the Constitution was ratified, so they didn't know that they would need traffic laws. Of course, that belies his ignorance, not knowing that the federal government doesn't put out traffic laws. But regardless, so what do people mean when there's a good living Constitution and a bad living Constitution? And believe it or not, there is a good living Constitution, and this coming from the 10th Amendment Center. What is the purpose of a Constitution? So the purpose of a Constitution is twofold. First, it lays out how you're going to organize your government, how long senators are elected for, who elects them, how long the president's elected for, who elects them, what the powers of Congress are, etc., etc., etc. The other more important power of the Constitution is it restrains government, especially a written Constitution. If we have a written Constitution, what's written on the page is what the government's allowed to do. So the idea that the necessary and proper clause, which states, by the way, to make all laws which shall be necessary and proper for carrying into execution the foregoing, and that's very important, powers and all other powers vested by this Constitution in the government of the United States or in any department or officer thereof. So what that means is that for the previous powers, and this power appears at the end of the list in Article 1, Section 8, that Congress has incidental powers. Now, this is explained by Hamilton in Federalist 33. He goes through a lengthy explanation. I'm not going to read the whole thing, but a couple of things that he puts in is the operation of the intended government would be precisely the same if these clauses were entirely obliterated. Now, the two clauses he's referring to is the Supremacy Clause and the Necessary and Proper. So that what he means there is that we could take this out, and implicit in the Constitution is still the powers that are granted by the Necessary and Proper Clause, the incidental powers, and I'll get to that. And then he also says later in the same paper, Federalist 33 again, what is a power but the ability or faculty of doing a thing? What is the ability to do a thing but the power of employing the means necessary to its execution? What is a legislative power but the power of making laws? What are the means to execute a legislative power but laws? What is a power of laying and collecting taxes but a legislative power, or a power of making laws to lay and collect taxes? What are the proper means of executing such a power but necessary and proper laws? So what he's saying very long-windedly is that all this does is make clear what is already implicit. The fact that the legislature has the power to do the things before it already means, because a legislator's ability to do stuff is dependent upon passing laws, that they would have the power to pass all laws that are necessary and proper to do the foregoing powers, to enact the foregoing powers. Now, the foregoing powers, again, the powers that come before it. So,
could you explain the incidental powers?
I was going to get to that. So an incidental power is, it's a power that's necessary to fulfill another full-size power. So say they have the power to raise an army. Now that's a pretty important power, but it doesn't specifically say that they can build barracks. Well, if you have the power to raise an army, you have to be able to build barracks to house the army in. You have to be able to buy guns to equip the army with. You have to be able to do the minor things that are necessary to fulfill the major power. So what an incidental power has to be is it has to be smaller than the main power, and it has to be absolutely necessary, not merely convenient, to bring into effect the major power. So now we've come to this idea, right? We understand what incidental powers are and what the necessary and proper clause means. So if the necessary and proper clause were to mean that the government would be able to change, based upon different times, and the only person who was to decide if the government could change was the government, then what actual power is the written Constitution to restrain the government? Now, people would say, well, the Supreme Court is supposed to enforce the Constitution. We kind of come up with the same idea. Well, the Supreme Court's part of the federal government. And what actual limit on government is it if government gets to decide what government's powers are? So with this understanding of a living Constitution, which is unfortunately, our country is infested with politicians that believe this. And with this understanding, what we have is a dead hulk of a country, a dead hulk of a constitution, a dead constitution, not a living constitution. But there is a way that our Constitution is living, and I'll explain it to you right now. It's Article 5. Article 5 of the Constitution reads something like this: the Congress, whenever 2/3 of both houses shall deem it necessary, shall propose amendments to this Constitution, or, on the application of the legislatures of 2/3 of the states, shall call a convention for proposing amendments, which in either case shall be valid to all contents and purposes as part of the Constitution when ratified by the legislatures of 3/4 of the several states, or by convention in 3/4 thereof, as the one or the other mode of ratification may be proposed by the Congress. So what you have there is a method of changing the Constitution, and by that method it is a living Constitution. Now that's happened over 25 times in the history of our country, that we've eliminated slavery with that. We've added rights, and we've allowed women to vote with that. We've done all kinds of things with that, the amendment process. So the amendment process is the way to change the Constitution. And there is a well-known, or at least it was at the time of the founding, it was referred to several times in the Federalist Papers, concept in construction of constitutions, and that is that an affirmative in one case implies a negative in all others, and that in plain English means the fact that they put in the Constitution, Article 5, a method of changing the Constitution, means that no other method of changing the Constitution is valid. So when they say that the Supreme Court can change the Constitution by coming down with a different ruling, well, that's invalid. The Supreme Court can't change the Constitution by merely saying something was actually interpreted wrong a long time ago. You have to actually follow an amendment. You can't, the president, saying that he has the power to declare war or to make war without a declaration is an amendment. We can't allow that without an amendment to the Constitution. If these powers are actually for the better, and I could name, literally scores and scores of laws that enact powers that Congress or the President or the Supreme Court does not have. Well, if these powers are actually for the better good, then we need to pass amendments to make them happen. And if we're not going to pass an amendment, then we need to not allow our government to do that. Anytime we allow our government to exceed the Constitution, they become tyrannical by their nature.
Okay, so the gist of this, we've discussed this in other videos, that essentially the whole point of a constitution is to limit the power of the federal government. And they are essentially taking these necessary and proper clause and using it as one of several excuses to exceed their authority.
Absolutely. And that's something we can't allow to stand.
Okay, we've been talking with Tim Reeves of the Oregon 10th Amendment Center. Thank you, Tim, for your time.
Well, thank you.